Before I became a lawyer, I didn't understand how the court system worked. All I knew was that I would hear names about lots of different courts and the state system and federal system, and didn't really understand how they all work together. But it's really quite simple when you look at it. In Georgia, we can divide the courts between appellate courts and trial courts. At the trial court level, you're going to have three different types of courts. You're going to have your magistrate court. Those are for disputes $15,000 or less. Think of it like the People's Court or Judge Judy. A lot of those people represent themselves, but it is for those small claims. Then you have your state courts and your superior courts. State courts do not exist in every county. A lot of smaller counties don't have a state court, they only have a superior court. If your county does have a state court, the state court hears misdemeanor criminal cases and any civil disputes that don't involve either a request for equitable relief or a family law claim. In superior courts, they have jurisdiction over felony criminal cases and all civil matters, and that's going to include cases involving family law disputes like divorce or child custody issues. Now at your appellate level, you have the Georgia Court of Appeals and the Georgia Supreme Court. The Georgia Court of Appeals sits below the Georgia Supreme Court, and litigants in a case at the trial court do have an automatic right to appeal to the Georgia Court of Appeals after final judgment. Now after the Georgia Court of Appeals renders their decision, they do not automatically have the right to go to the Georgia Supreme Court. That is what's called a discretionary appeal, and the litigants in the case have to request that the Georgia Supreme Court hear the case. And there's a very high standard for doing that. But that is a brief synopsis of how the Georgia court system is structured in our state.